We have also made a provision under 161. Those of you who know about constitutional development in Fiji, for example, when the Parliament and Senate approved the 1997 Constitution, it took them nearly 1 year to clear out the cobwebs in the Constitution. They found typographical errors. They found that there were certain sections weren't married well enough. It was not collaborated enough to function. There were some technical aspects to it that they found. We've given ourselves 3 months. What we are essentially saying, once the Constitution is assented to by His Excellency the President, we have until 31 December 2013 to clear out any aspects. Maybe 2 full stops. I've already identified one mistake where it should have been judicial services and it says judicial service. Those technical aspects, semantics. But we've given ourselves until 31 December. But we can only amend it once the assent is given to the Constitution if we get certification from the Supreme Court. So we have to turn up to the Supreme Court and say, my lords, we have to change service to services because of X, Y, Z. Once they give the certification, then it's taken up to Cabinet, which then recommends a change in the President for President's approval. The last section or last chapter is the definitions, etc., but also an important provision here that talks about the transitional provision. Once the President assents to it and the Constitution comes into effect, what happens from then, say hypothetically from September the 6th until the elections are held or until the first Parliament meets? Obviously there's no leader of opposition. Obviously there's no Parliament. And there are certain provisions in this Constitution that refers to the leader of opposition, that refers to the Parliament. So this section here, the transitional provision, takes care of that. So essentially what it says, the example that I gave you about the Constitutional Officers Commission, one of the persons is to be appointed by the leader of opposition, so we don't have one. Now, what this section says, for example, in that instance, all the role of the COC is to be performed by the Prime Minister until such time as the first sitting of Parliament. Because if, hypothetically, the Prime Minister steps into the shoes of the leader of opposition and appoints somebody to the Constitutional Officers Commission, when the leader of opposition is in fact appointed after the elections, the leader of opposition may not like that person. He say, I do not agree with this person being my nominee. But he cannot simply remove him, because the Constitution says you have to have a tribunal to remove somebody. So these are the sort of technical aspects that are taken care of, and that's what it provides for. For example, also Section 170 talks about the elections. It gives some specific timelines. As we've said, the Prime Minister has highlighted on a number of occasions. It is categorically stated the elections will be held next year, and it cannot be held any later than 30th of September 2014. And there must be at least a public declaration or announcement by the President at least 60 days before the date of the election. So you will know when exactly the elections will be held 2 months before, at least. He could make the announcement 90 days before, but it must be a minimum of 60 days. The writ of elections must be issued at least 44 days before the date of the election, and the nomination for candidate for Parliament as a candidate shall be 30 days before the date of the election. So you must know 30 days before the date of election who the candidates will be. Before I also forget, there's a provision, as I mentioned to you, that we now allow for dual citizenship, multiple citizenship. If you're a registered Fijian voter with a valid passport and you hold the citizenship of any other country, you can vote in the elections. But you cannot stand in the elections. You can only stand in the elections if you're only a Fijian citizen. This provision is not unique to Fiji. Australia still has that rule about that. In fact, I worked for a law firm where you used to specialize in revoking people's citizenship. We had a lot of British passport holders who would stand for elections, generally for the Liberal Party, but they also held an Australian passport and a British passport. So they would give up the British passport in order to qualify to stand for the elections. So we also have the provision The rationale for that, some people have asked that, and I know some of you may hold citizenships of other countries, is that you need to have complete loyalty. You may be passionately, you are completely loyal to Fiji, but also legally. I mean, assuming that if you hold citizenship of, say, New Zealand and Fiji, and you get elected to Parliament, and you become Minister for Industry and Trade, and you have to go and negotiate a trade agreement with New Zealand, where will your loyalty lie? So, I mean, these are some of the practical implications or reasons for putting that, that you need to have only one citizenship if you're going to stand for Parliament. We also had a very quirky provision in the 1997 Constitution. It said that even though you're a Fijian citizen, you had to be resident in Fiji for 2 years immediately before voting. Now that obviously cut out a lot of people. There are a lot of people who are living overseas and working overseas, not necessarily through choice, or they have to go and work abroad. You could have somebody effectively working in one of our embassies for 3 years. They won't be able to vote. You could have somebody who's serving as a security officer in Afghanistan, or working as a nurse or a caregiver in California. They would miss out, but they're Fijian citizens. So this essentially says as long as you're a Fijian citizen, you have a valid passport and you're registered, then you can vote. But you cannot stand for Parliament unless you have only Fijian citizenship. This provision also says, if you look further down, under 167 and thereby onwards, that as far as the decrees are concerned, all the decrees that have been put in place by the Bainimarama government will continue. The validity of those decrees cannot be questioned. But once a new parliament is elected, that parliament can change any decree it likes. It can repeal it, it can get rid of it completely, it can amend it. That's the choice of parliament, because the parliament represents all the voters, or people who voted them in. But that parliament cannot retrospectively change any of the decrees. It cannot retrospectively change any of the decisions that were made under the decrees. So, for example, the Bainimarama government has put in place the domestic violence decree. There are some people who may have been sentenced to imprisonment under the decree. Some people may have been given orders, to not go 50 meters within the spouse, etc. Now, if the new parliament comes in and says, no, it's okay, we don't need the domestic violence decree, let's get rid of it, that's fine, they can do that. But it cannot go back and say, let's pay compensation to the guy that was sent to prison under the decree. It cannot go back and challenge any of those decisions under the decree. So it is to provide stability and a way forward, and it gives Parliament the full ability to change any of the decrees they like, but it cannot go back in time. And effectively, that's what the rest of that transitional provision talks about. It also, before I conclude, it's important for people to know this because it does affect your organizations. If people have, sometimes members of the private sector also lodge complaints with the Human Rights Commission regarding employment issues, as it does have the ability to cover that area, which is subsection 5 of section 171. What this says is, if any complaint has already been lodged with the Human Rights Commission, which will be known as the Human Rights and Anti-Discrimination Commission after the Constitution is sent it to, then the Human Rights Commission must investigate that complaint. They must proceed and complete that particular complaint, whatever is involved in providing a resolution to that matter. But the Human Rights Commission cannot receive complaints after 21 August, which is the day we announced it, on any complaints that relate to events that took place prior to that. Because one would expect that if you had a complaint, you should have lodged the complaint almost immediately. So it gives the Human Rights Commission a clean slate. So today you can go and lodge a complaint. That's not a problem. But the complaint that you lodge today must arise from an event or occurrence that has occurred today, or even occurred yesterday, but not an event that took place 1 year ago or 6 months ago. So that's the provision that's been put there to give them that confidence and stability to the Human Rights Commission.